Good morning and happy Valentine's Day. I'm doing this weekly update on Thursday because I'm going to take tomorrow off. I'm tired and I need to recharge my batteries. But let me tell you what's been going on this week. First of all, 1097, that's the work comp bill that requires if work comp carrier declines or refuses to pay for any reason, the health insurance company must pay, subject to subrogation should it ultimately be decided that the work comp or the injury was work related. That passed the Senate 35-0 yesterday afternoon, and so that's been passed by both houses, and it'll go on downstairs to second floor for the governor's signature. 1106, that's the revised LLC limited liability company bill. That is on the consent calendar this afternoon in the Senate. I'm informed that they are not nobody's going to take it off consent, and so that likewise will pass today and go downstairs to second floor for a signature. 1096, which is our transfer on death deed bill, that's going to be held or heard in Senate Judiciary this coming Tuesday, probably about 9 or 9:30. Senate Bill 218, that's our rural lawyer scholarship program or funding program, that passed the Senate Judiciary Committee 7-0 and then was sent to the Appropriations Committee because we need roughly $625,000 to fund that for a 4-year pilot project. That was heard in Appropriations Committee this morning. The Chief Justice and Senator Valley and I all testified in favor of it, along with the State's Attorneys Association and the county commissioners supported that. We have to wait and see. There's a limited amount of money available, and there's all kinds of good, warm, fuzzy projects that are requesting funding. We're competing with all of them. We'll have to wait and see. I suspect that the Appropriations Committee will decide either tomorrow or Tuesday which of those good meritorious bills are going to get funding and which ones, despite their merit, they don't have the money for. But we had a good hearing. 1061, which is not a state bar bill, but the bar commissioners voted to support it. That's the captive, that expands the captive insurance company laws and specifically allows trusts to form captives. That probably is going to be, that's through the House, we supported it. It's going to be heard in Senate State Affairs either on Wednesday or Friday next week. We just don't know which day. We have two remaining bills. The surrogacy bill has managed to attract attention from both the people who don't think that anybody ought to be able to use surrogacy and those who think there are not to be any restrictions or controls on it. We've attracted the attention of both, and so we've decided that we're going to table that bill. That'll be tabled tomorrow. The model is there if in the future the issue comes up again, but that is going to be tabled. I do appreciate all the hard work that the Family Law Committee put in to come with this draft. It tried to strike a middle-of-the-road path, but rather than put the legislature through a grueling battle, the bar commissioners and I decided that that should be tabled. The power of attorney for health care, it has gone through 3 drafts or 3 redrafts, and frankly, if it's got to go through 3 redrafts, it probably isn't ready to go. And so I talked with the prime sponsor, Representative Johns, and he's going to table that bill tomorrow, and we can consider that at our leisure. If something that important that's going to be a form and put into the code, which becomes the default, we got to make sure that it's right. And with this kind of controversy that's arisen, it's not right. It's not right and it's not ready. And rather than hurt our credibility, particularly in the Senate where there are no lawyers, it's far better that we kill the bill ourselves and we rethink that process, and that's what the bar commissioners decided to do. The last bill I'm going to talk about is 1231. Now 1231 would amend one of the 7 categories of interest rates after a judgment is obtained. And the prime mover on that is a lawyer lobbyist who came to me early in the session, and he came to the trial lawyers too. And he said, I've got an out-of-state insurance company that hired me to pass this bill, and he showed it to us, and I said, and he wanted to know what the trial lawyers were going to do, and Roger Tallenhusen said, well, I can tell you we're going to be against it. And he turned to me and said, what about the state bar? And I said, don't know. I'll send it out to the board, and I'll let you know what they decide. And I sent it out to the board, and the board had a number of questions. The bar commissioners had a number of questions. Why are they only amending one when there's 7 categories? In the past, we've always, if the legislature decided that we needed to take a look at the interest rates on those judgments, they've looked at them all and adjusted them all. Why just one? And I said, no explanation, I've got my suspicions. The other concern that they had was that to the extent that you reduce the interest rate on judgments, in effect you encourage delay and you encourage appeals, because there is no question that if there are substantial damages that are not pain and suffering, because you don't get prejudgment interest on any of those, simply your lost wages, your hospital bills, those things that are definitive from the date of the injury, if those are substantial, then an interest rate, on prejudgment interest rate, encourages some settlement. And the greater the harm and the damages, then the greater incentive to resolve those issues. To the extent that you reduce that one category, then you encourage delay, because the amount of interest that an insurance company can make on its reserve is equal, or perhaps even if you take the bill called for prime plus 3, and my research indicates that the return is about 0.5% higher on what the reserves are getting from the insurance companies are getting over what that interest rate would be, and that encourages delay and it encourages appeals, and our entire profession gets blamed for that. Our entire profession gets blamed for that, and that's wrong. And it's bad public policy to single out one. Now, the protocol, although it's not required, is that when the state bar is going to take a position in opposition to a bill, I go and I tell the prime mover, we are opposed to your bill, and I did that in this case. Furthermore, the protocol is that I go to the prime sponsor and also advise them of the opposition, and I did that in both cases. Now, yes, this bill was going to be taken up yesterday. Well, Tuesday afternoon, actually Tuesday evening, I talked with a number of lobbyists whose organizations were going to lobby in favor of this, and we all agreed that that bill was going to be dead. And the question was, are they going to get 1 vote, 2 vote, or 3 votes in favor of the bill? And so that's business as usual. We knew. Sometime late on Tuesday, apparently the defense lawyers organization decided to take a position in support of the bill. They never told me. They never told the bar commissioners. My first knowledge of that opposition, or that they were going to support it, came at 10 o'clock at the time that bill was going to be heard. Now, we are very careful when our members are split. In this case, we had no notice that they were going to split. And I told the committee, and you can go back and listen to my testimony because it's all recorded, that typically the state bar does not get involved in tort reform or such bills where our own members are going to be divided. But there are a number of exceptions, and I want to use this opportunity to discuss this with you, because I work for all of you. There are a number of exceptions when the state bar historically has always taken a position. One, when proposed legislation interferes with the ability of our juries to resolve disputes. Secondly, we get involved when a proposed bill interferes with the ability of our judges to do the judging, to resolve those disputes. And the last category where we get involved is when a proposal is fundamentally unfair and alters a level playing field. And 1231 fell into that category. And I explained that to the committee yesterday, that's why we were involved, and that it was fundamentally unfair to single out one category and say that our economy justifies a reduction, but none of the others do. It's never been done before in the 30+ years that I've been up there. Never been done before, and this was a bad precedent and bad public policy, and that's why we're opposed. The other thing I'm going to leave you with is with this, and I'm the first one to admit my testimony was a little bit angry. And I got angry because the chief proponent was an out-of-stater that is employed by a tort reform organization. And he testified and told the committee that this bill would help defeat frivolous lawsuits. Well, excuse me very much. This bill, this interest rate doesn't come into play unless and until a judge and jury have already decided that there was a negligent party. So the issue of frivolity has already been resolved against the people that they're trying to benefit with this bill. And that's wrong. And that's why I got angry. So anyway, that's the report. That I can tell you that bill went down 12-1. And the one vote probably was a gift. And the prime sponsor and 4 other sponsors on that bill sitting on the Judiciary Committee all voted against their own bill. Thus, the bill deserved to die, and it did die. And that's it for the week. I hope you guys have a great weekend. I'm taking tomorrow off, and I'm going to relax and tune in next week. Hopefully we're going to be able to say that most of our bills are going to be concluded by the end of next week, but we'll wait and see. Thank you.